apropos.
All right. So, good news is it's Friday and it is February 16th. This is Senate Health and Welfare. You want me to do this? Let's do it while we're on. Let's see.
We need happiness.
Let's hope it's good.
Well, I have happiness.
Go for it.
Tomorrow's my birthday.
Yay! Oh, happy birthday, Sharon.
I have cookies if we want cookies, but I'm not in the mood for a cookie right now, but if anyone wants some.
Probably by 11.
I bought some at Bohemian, sorry.
Places,
I am Aquarius.
Aquarius.
Yeah.
She's a
So you're
Aquarius.
wearing the color.
Oh, here it is. Here it is. You ready?
Yeah.
Watch puppy videos online. Yeah. That'll make you feel good.
Always.
Super Bowl.
Puppy videos, and you know what is almost as good as me? Go baby go.
Baby goat.
Yeah,
Baby
actually
goat
better.
It goes to the best.
Yeah.
Okay, so I can see that there's a lot. I think that you two haven't watched the
Asian
puppies on that.
That's the best, they're so cute.
Okay.
Go
And they're
therapy.
useful. It keeps the brush down.
Yeah, they're useful and cute.
So here we are. We have a little extra time this morning and Katie has been doing some great work for us on S-192.
As always.
And as always, so Katie, why don't you come up and you can share, do we have it on our webpage? You do? Yeah, okay, so we have some, you explained what the language is. I went through it and it looked,
Okay,
like a good consolidation.
good morning.
Good morning.
Katie Whitman, Office of Legislative Counsel. So I have a document that I will share. Let me give you a little bit of background about what this document is. So when we left 2 days ago, there were a lot of sort of big technical issues that you had asked either me or Stuart or Karen, and so we met in the afternoon 2 days ago to try to sort through some of those issues. And so what I've done is I've sort of cut and paste language from the bill and dropped it into this document. And the changes are highlighted in green, but I thought this way you can sort of see the conversation we had and the language that the three of us landed on before it gets into your bill and see if you even like the concepts or not. So I thought I would talk you through that.
So does it replace sections of the bill? Or does it just moves things around more logically and?
Let's see, it adds a new section and completes out 3 sections. And then there are 3 sections of your bill that I've just cut and paste and I've edited.
Okay,
So I can kind of talk you through this document.
let's look at it and then we can decide how to go. Maybe, probably will be important to see it within the bill itself. But let's start with this.
Okay. So the first issue that we were kind of grappling with, if you remember, there was language on the expedited hearing in the mental health context. And the language was duplicated twice, and we were having a conversation, was it necessary, was it not? And that felt like a bigger conversation that Karen and I needed to have. In the interim, Karen spoke with the assistant AGs assigned to the Department of Mental Health. And their observation was, as they were looking at the bill, well, actually, we don't need to amend the sections on application for involuntary treatment and the related hearing and order, because individuals who are coming through that criminal door, there is already a section in Title 13 that sort of governs their custody into the Commissioner of Mental Health, and an AIT is never actually filed for that population coming, for lack of a better
AIT
word.
being,
Thank you, application for involuntary treatment. So there's not that initial physical application as there would be under Title 18, under the population coming in the criminal justice system in Title 13. So as a result of that, I am proposing to add a new section to the bill. And I've highlighted the heading of this section, so you know it's a new section. This is from Title 13. And this section is meant to incorporate some of the language around specifying that a forensic facility is being sought and what a court would have to do to order a forensic facility. Take that language out of the sections of the bill that are right now in Title 18 and then remove the Title 18 sections, if that makes sense. So it would be moving that language to Title 13 and removing the 3 sections from Title 18.
And before we go through it, will the Title 13 sections be referenced within, is there a place to reference it so that there's,
I would have to look. I think there is some reference now. I don't have that at my fingertips.
okay.
But in one sense, the two systems, meaning mental health and intellectual disability in this regard are more parallel than we had realized. Because when we talked about the developmental disability system, we said, well, the court is sort of, if there's an incompetency determination, is sort of automatically moving to is commitment appropriate. And in this case, we're sort of seeing that too, that now there's not an application for the individuals coming through the criminal justice door. First, we have existing language that really wouldn't change in subdivision A1. That if the court finds that a person is a person in need of treatment or a patient in need of further treatment as defined in Title 18.
So make sure you go very slowly,
Okay,
and because right
Yeah.
now you're going
Yeah,
about
I
70
proceed.
miles an
Yeah,
hour.
I
You probably need
apologize.
30.
Yep.
Especially because it's Friday.
okay.
And it's Friday.
Okay, so this language, again, is in Title 13, it's existing language. That if the court finds that a person meets criteria as defined in Title 18, the court is to issue an order of commitment to the Commissioner of Mental Health and shall admit the person to the care and custody of the Department of Mental Health. So the current language says an indeterminate period. Karen was reminding me that she had had a conversation that even though there's this language that it's an indeterminate period, there is case law that really narrows this down to a period of 90 days. And I asked her, well, could we just say that then? She said, sure. So that's why I've struck through an indeterminate period and put a period of 90 days, which is consistent with the initial order in Title 18. In any case involving personal injury or threat of personal injury, the committing court may issue an order requiring a court hearing before a person committed under this section may be discharged from custody. So that's existing law. And now I'm moving language that should look very familiar to you from the Title 18 portions of the bill, and I'm moving them here into Title 13. And this has to do with what happens if the commissioner wants a person placed in a forensic facility. That's subdivision 2, and subdivision 3 is how does the court make the determination that that placement is appropriate. So in subdivision 2, if the commissioner seeks to have a person committed to the commissioner's custody who is under an ONH, receive treatment, an ONH meaning order of non-hospitalization, receive treatment at a forensic facility, the commissioner shall submit a petition to the court expressly stating that such treatment is being sought. So even though we're saying this is sort of more of an automatic process that's happening, if the commissioner wants the person to be treated or placed in a forensic facility, then the commissioner has to file a petition to that extent, seeking that. So this, what would be in the petition? A statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment for the person's condition can be provided safely only in a forensic facility, and a recommendation of the Human Services Community Safety Panel. And then we have language about how the court makes the order. So if the commissioner determines that treatment at a forensic facility is appropriate, and the court finds that treatment at a forensic facility is in the least restrictive setting adequate to meet the person's needs, the court shall order the person to receive treatment at a forensic facility for a period of 90 days. The court may, at any time, following issuance of an order on its own motion or on motion of an interested party, review whether treatment at a forensic facility continues to be the least restrictive treatment option.
Okay, so give us the.
The high level again?
Again.
Okay. So this is Title 13. And similar to the structure for the court process for individuals with intellectual disability. In the 2 days since we last met, the AAGs let Karen know that there isn't an application for involuntary treatment under Title 18 filed for individuals coming in through the criminal justice door who are found not competent to stand trial. Instead, like the intellectual disability system, there's more of an automatic process where the court will look at whether commitment is appropriate. Because of that, it doesn't seem to make sense to amend Title 18 with regard to the application for involuntary treatment and the related hearing and order on that application. So instead, I'm amending this language in Title 13 to pull in those concepts here, so that if the commissioner, at the time that the criminal division is looking at this issue of commitment to the Department of Mental Health, if the commissioner thinks that the forensic facility is the best location for the person, they have to file a petition with the court saying that. And then it provides direction to the court as to when to make that order.
What's the mechanism for that happening? I mean, how are they gonna know that they have, commissioner have somebody in the courts?
I would say that's the nuts and bolts of how that works is probably a better question for DMH. But if somebody is being considered for the custody of the commissioner of mental health, my understanding is that DMH would have some awareness of that. But I can pull down my screen if you want to hear more from Karen.
Let's ask that question. Is Karen Barber there?
Sure, yes.
I feel like Karen and Stuart are always just like.
Karen and
moving.
Stuart are floating. Thank you. Thank you for
Always
being-
hovering.
Good morning, for the record, Karen Barber, General Counsel of DMH. Yeah, so what happens is that once the court makes an order to have a competency evaluation done, we get the order, right? So we know when that process starts, and then we get the outcome of the evaluation. So we know if someone's found incompetent, and so then we know that at that point, we're discussing with the state's attorneys and the Defender General what the plan is. Are we going to go to commitment? Is an OH or an ONH appropriate, or are we not going to do anything? So as soon as the evaluation is ordered, the process starts, and we're a part of that.
Title 13's criminal.
Yes.
Yeah.
Yes, but because we are the ones that do the evaluation, the court gives us the order for the evaluation. So we actually receive it, and then we receive the evaluation back from the evaluators.
Okay, thanks.
Okay, question, go ahead.
So just by removing those 3 sections, I was just looking back in
Wait till we get there.
oh, we have
She's-
gotten there? Oh.
She hasn't talked about removing something yet. Let's just be clear on what this is. Now, here's how we'll do it, and then we'll
Okay.
have Katie explain that. And then we'll go on, and after we've done all of this, then we'll try to put it into the broader context. Bill,
Okay.
yeah, so go, now are there any other questions on this section, the way it's written? Awesome. Now let's go back, and now we're gonna get ready for Senator Hurley's question about the sections.
Okay. So, I didn't number these pages, which is not helpful. But at the top of page 2, I sort of have language in brackets, and that shows what is being removed from the bill. Sections 5, 6, and 7, which is the application for voluntary treatment, the hearing on application for voluntary treatment, and the order on non-hospitalization. Those sections are all being removed. I think your question is gonna be what happens to the expedited hearing.
Yeah.
So that is not an option, as this is drafted, and I understand, standing with Karen, and I'm sure she'll correct me if I get this wrong, is that, that the process coming through Title 13 happens pretty rapidly, so the need for an expedited hearing when it's coming through the criminal division is not as essential as it could or would have been if it was coming through Title 18.
Okay. I do appreciate that that section 6, which was the one that was really confusing to me because of the repetition, that's gone. But I know the answer to that, I'm gonna ask anyway. I mean, when they're gone, it just means that the current law is staying for
Yes.
those sections. And
Exactly.
we're not messing with them at all.
Yes.
Okay.
They won't reference the forensic facility, just like for the secure residential recovery facility. It's only referenced with regard to the application for continued treatment. That will be the case for the forensic facility also.
Okay, and section 5 only had like very little, there was paragraph G in section 5 that added that, that's not necessary. Okay,
Do you all wanna look at the sections that are being changed? I've done, I'm happy not, I think if you wanna do that, we should. Everything that is in those sections is now essentially covered in this section in Title 13.
With the exception of the expedited option, that is not
Which
there.
is not needed because it's going through the courts quickly. And then also the 90 days, we can change that indeterminate period to 90 days based on case.
Yes, and then it is consistent with Title 18.
I mean, is in Title 13, are there any requirements that the court hears something within a certain number of days?
I don't have it.
For competency, we did that last year. We did this. Karen, are you there?
I am. Yes. So once a person is found incompetent, they can only remain in corrections for, it was 15, we changed it to 21 days. So the court is having hearing within those days. Often I will say we generally stipulate. And so we're doing it fairly quickly. We have a sense, so what happens is, right, there's an evaluation and we know the outcome, whether or not the evaluator said they thought they were competent or incompetent. We quickly get a sense from the parties whether or not that's going to be challenged, because if it's going to be challenged, then we kind of wait to see how it plays out. But if it's not going to be challenged, we know that the court is going to schedule a hearing. And so we're starting to work before the hearing is even scheduled to figure out what we're going to do. So it's a pretty rapid process because the person can't remain incarcerated while they are found incompetent for a period longer than 21 days.
Okay, that's helpful.
Katie, mentioned another acronym, AAC.
AAG, sorry, the Assistant Attorney General.
Okay.
So there are Assistant Attorney Generals that are assigned to each department, and that is who Karen consulted prior to us shifting these pieces around. So there are, I think, 2 assigned to DMH, and she spoke with them, and they were the ones who indicated that an application for voluntary treatment wouldn't be filed for this population coming through Title 13, but instead it would be more of an automatic process after a competency finding or lack of competency finding was made.
Okay.
Good, okay, good.
Are we all set with the 3 sections then?
Okay, so there's another piece to this, which is how it interacts with the application for involuntary medication. So this is from your underlying draft to your section 10. But if you remember, we're adding a new situation or instance in which the commissioner could seek involuntary medication. So one of those was a person has an application for voluntary treatment at a forensic facility pending, and the court granted the motion to expedite. But because the option to expedite is gone, this is a corresponding change. So now, as related to the forensic facility, the only time that the commissioner could seek involuntary medication would be if the person has been placed under an order of non-hospitalization at a forensic facility. So the person is already under the order at the forensic facility.
Okay, so we're getting rid of or on all of that.
Yep.
I'll let cross out.
Okay. So that is the changes in the mental illness portion of the bill, and now we're switching to commitment relating to intellectual disability. So the yellow highlighting, I just want to be clear, is because I cut and paste right from your bill, so what's yellow in your bill is it's yellow here, but the green is where I was making changes to sort of draw your attention to today. So the conversation here that we were having, and that wasn't settled when we left 2 days ago, if you remember, was a conversation about, when there is an administrative discharge from the commissioner, should there be an opportunity for, a hearing? Should the prosecutor and the victims be able to ask for a hearing related to that administrative discharge? And then there was a conversation, well, should it be parallel to what happens in the mental health context? And the conversation between Karen and Stuart sort of indicated that creating true parallels would be really tricky because there was a lot of nuance involved. So instead, the language, oh, that's a small. I'm gonna skip over this and come back to it. So in 8847, I'm on page 8 of the draft.
Wait a minute. Oh, so you're skipping over page 5?
Yeah, I'll come back to that
That's it.
since I've already,
Wait, what?
What?
Which draft?
The thing that she's looking at up on the screen,
the document.
The 9
I brought was
pages.
Okay.
Yeah,
the
not,
9-page document.
yeah, I know it's confusing to have two
What page
documents.
you want to?
I'm on page 8.
Okay, and
Um,
yellow and green, it's very pretty.
yeah, the paragraph C1A, and I'll flip back to the other green, I forgot that was there.
Okay,
Okay, and so there was a conversation, should the hearing happen? Should it not happen? What should the time frame be? So in the end, this is the language, that folks landed on, which was that if the commissioner determines that a person is no longer a person in need of custody care and rehabilitation or continued custody care and rehabilitation, the commissioner shall issue an administrative order for discharge of commitment. An administrative order for discharge of
just go back
commitment.
slower.
So this is authorizing the administrative discharge. If the person doesn't meet criteria, then the commissioner can discharge the person. The order to discharge from commitment can be conditional or absolute, immediate or delayed effect, at least 10 days prior to the effective date of the administrative order for discharge by the commissioner from commitment, or 10 days prior to the expiration of a current commitment order for which the commissioner has decided not to seek continued commitment. So in other words, the person, not just that the person is in the middle of their order and the commissioner is seeing that they no longer meet criteria, but the commissioner knows that this person's order is ending and has decided not to file again to continue to hold the person. The commissioner shall give notice of the pending discharge to the committing court and to either the prosecutor, and to the prosecutor of the case. And that corresponds with the hearing piece below in this subdivision C. So during the period in which the commissioner gives notice of the pending administrative discharge that we just looked at, and the anticipated date of the administrative discharge, which shall not be less than 10 days, the state's attorney, or the office of the attorney general, or the victim, or both, may require a hearing in the family division of the Superior Court on the person's pending administrative discharge from the person's placement at a forensic facility, which shall be held within 10 days after the request. And the pending administrative discharge from placement at the forensic facility shall be stayed during this notice period. So,
Carry.
yeah, so this is basically saying that if you're going to ask for that hearing, it has to be within that 10-day window. And that, the hearing is to be held within 10 days of request, and the discharge, the person's administrative discharge, won't happen, during the notice period.
Okay,
Questions there?
need to read it again.
We're gonna, well, when we go back through the whole thing, the whole bill, have this in place and.
We're talking the Commissioner of Mental Health.
No,
No,
this
Dale.
is Dale,
Dale.
right, this is the intellectual disabilities section.
Okay. So they,
I do have one question here, and we don't need to get into discussion with it right now, but victim notification is not occurring here.
It is, we haven't changed that section,
It's still in there.
so that's 2A.
I just please. Okay. We just want to make sure we don't leave anything.
and the victim can still request a hearing. But it is that 10-day window
Mhm.
during which then it's stayed and the hearing has to be requested. So how long until they have to schedule the hearing?
Well, it has to be held within 10
Oh,
days
it's held
after
10
the
days.
request, so.
Oh, right.
In theory, just to play this timeline out, so you have a 10-day window to request the hearing, so. Let's say the prosecutor requests it, right before the 10 days expires, and then it has to be, and then the hearing itself has to occur within 10 days. So at most, somebody would be held about 10 days past the planned administrative discharge date.
Got it.
It's worth noting that this fee, and I think we've said it before, this only applies, this option for a hearing, for an administrative discharge from person's placement from a forensic facility. So this isn't commenting on the person's discharge from commitment generally. It could be, that's a policy choice, but that's what this language says.
Let's hold any discussion on that till we get to the full bill, but I think this is what, this makes sense right here.
Yes.
We can do the whole commitment thing. That's not here.
But they could be
Oh, here
released
it
from
is.
a.
Well, that's D, right? That's discharge from commitment from the.
This language is a little different in that it's saying that if the person is being discharged either judicially or administratively, then the criminal division that had jurisdiction over the person's criminal charges is going to retain that jurisdiction over those charges. And that the orders, they were placed on hold while the person was in Dale's custody. But when the person is discharged from the from the commissioner's custody, and they go back to a correctional facility, then the commissioner of Dale ceases to have custody over that person once they enter the correctional facility. So that's sort of the transfer of jurisdiction of the charges and custody of the person. And then I told you I skipped over some language. So I will go back to this.
It's up to the top of page
Thank you.
6.
So in my conversation with Stuart, he wanted to,
Okay, where are you?
I am on page 6 of the document, the new document today. C1. So, he wanted to make it clear, so we have language in the bill that an order can be up to 1 year. And he was wondering whether you could read into that, well, could there would a second order be permissible if the person's first order had been up to a year? Or could it be read that, well, somebody's done a year? So in order to sort of address that, we landed on the language highlighted in green. So if at the completion of a hearing in consideration of the record, the court finds by clear and convincing evidence at the time of the hearing that the person is still in need of custody care and rehabilitation, it is to issue an order of commitment for up to 1 year in a designated program in the least restrictive environment. It goes on to talk about discharge being governed in the next section. And then what the court should look at in determining if a person is meeting criteria. Then the last sentence, nothing in this section shall prohibit the commissioner from seeking nor the court from ordering consecutive commitment orders when the criteria for commitment are otherwise met. So that's just to specify that there could be consecutive 1-year orders.
Can you remind me where the criteria for commitment are? Are they in the bill or they're? Are they?
Yes, for commitment generally, it's in the definition section. If the person is a person in need of custody care and rehabilitation or continued custody care and rehabilitation.
It's in the definition section of, at the beginning of the bill or the
No,
beginning of the
no.
section on?
Yes.
Yeah.
So, let's see, page 20 of 6.1.
Oh, right, this is nested construction, right?
Did we go through page 5? Oh, that yellow is from our draft.
Yeah.
Duh, okay. All right, so. But I do want to go through the bill. I'm wondering if there's a way to go through the bill and also then look at the changes that are here. Sounds like fun.
You embedded these.
No, they're not embedded.
Yeah, no,
I was
you haven't-
afraid to muddy the waters and you hadn't weighed in on them, so I just
Yes.
wanted to plunk them into your draft. If you'd like the changes, I can do that.
I think we should. I think we should see those embedded in the draft.
Today or next week?
Well, but have we got that?
To do it well, I should probably
We
do it
can
next
do it.
week so I can read it and have it edited.
Let's do this, because I do want to go through the bill again. The intent was to go through the bill today, and then next week we could look at it again and get to a vote sometime during the week, next week. So why don't we go through the bill as it is, and then you'll find the places where you can say this
Right, yeah,
varies from
sure.
what we just did.
Okay, and I'll try to flag if there are places where I think there's an outstanding decision that you wanted to come back to, I'll try to flag that for you, but I know that you've also been flagging.
We
that.
got flaggers here.
Yeah, okay. So with the purpose and legislative intent section, you have already made the decision to change the date on line 14 to July 1, 2025 and to end the sentence there.
Okay, let's go through pretty deliberately so that we're getting still.
Sure. Draft number.
6.1.
6.1.
And my goal would be, if it works for the committee, to after we finalize decisions today, to come back with a 7.1 next week. With all of these changes we've been talking about.
Perfect.
Okay.
Can't wait.
He is excited.
I know, it'll be hard to sleep for the next 3 days. Okay,
Okay, but I won't because I do feel that way. You're right.
I read this bill, went through it in detail the other night, but right before I went to sleep, which I don't recommend. And then my brain was like processing it throughout the night.
Don't do that.
And I literally heard Karen and Stuart's voices trying to explain things to me. I was like, oh my God, this is really awful. So So you're in my head, Karen and Stuart.
All right.
The plan is working.
Yeah, exactly.
Okay, so section 2 is the Human Services Community Safety Panel. There have been some changes that you have decided on. But then there's also been a bigger conversation about, should there be a panel? If there is a panel, should Disability Rights Vermont have a seat on the panel? Don't know if you want to tackle that now or just have me flag that for you.
Let's stop here for a minute
Yeah.
and discuss it, because I think this is kind of an overarching question that folks have had. And, we heard from Stuart the other day that, the process is reaching out to all of these folks and making a decision. So what is the panel needed, or is other language needed? And I'm sort of asking this of Stuart and Karen, is other language needed that would direct the commissioner to, connect with interested parties? And I'll leave it at that. It's kind of the global statement, but rather than having the panel. And what I failed to do, and I meant to do it, I pulled up the Act 27 working group report, and I couldn't remember whether this was a recommendation from the working group or not. And then if from the working group, whether the panel was in that report, and that's one question. Second question is, I think there's an interest in having more than the commissioner involved in the decision making. Whether there's reassurance from you that it's going to happen with, talking with everyone. I think something in the bill needs to direct that. So before we go to other questions or comments, what I'm going to ask of you is A, is this something that was a recommendation of the Act 27 group? B, is it the panel that we need that's listed here, or is it a broader statement about working with others?
Certainly. So for the record, Stuart Scher, General Counsel at Dale. Senator, yes, the Human Services Community Safety Panel was a topic of conversation of the working group, although it wasn't discussed necessarily in the context of whether it should be abandoned in its entirety. There was more discussion around the composition of the panel. So yes, there were some members of the working group that did believe that there should be external individuals on the panel, or at a minimum that there should be some language that would direct the commissioners or the existing members of the panel to consult with others as needed. So that was really the scope of what we talked about in the working group. As Karen and I have tried to point out in the last couple hearings, the practice is currently existing whereby the Commissioner of Mental Health, at least because that's where there's a determination as to a number of different settings where an individual may go, is making that decision internally through discussions with others. So there are those discussions that are made, and again, those decisions are merely recommendations to the court. It's not as if the Commissioner of Mental Health, or in the future with a forensic facility, the Commissioner of Dale, would simply be able to say, we've looked at everything and this person is now going to the forensic facility. It's simply an internal decision.
We understand that. That was very clear,
Right.
in what you said the other day. So then the question is should legal aid be consulted in the process? Should the disability council be consulted in the process? They've been very interested in this, depending on who we're talking about. So,
Sure.
Yes.
The proposal that we've come up with, and we have some language, if you'd like, for us to share with Katie, would potentially eliminate the panel, because this practice is currently occurring, would still then direct the commissioner as to what must be considered in making a recommendation. And then once that recommendation is made, notice could be given to Disability Rights Vermont or the Ombudsman in general, so that they may reach out to legal aid who will be representing the individual at the hearing and will have an opportunity to consult with the individual's attorney in advance of that hearing. So there are currently factors in the statute that are attributed to the role of the panel members. We would suggest that those same factors be required of the commissioners in making their recommendation. Once the recommendation is made, the ombudsman on the mental health side and the disability side be notified so that they can then reach out to the individual's lawyer.
Got
And
it.
just to be clear, legal aid would already know because they represent the person. So they are already a part of these conversations. So they are already aware of what's going on, but it would, there's been, I get a sense from the committee that there's a desire to have more than just legal aid. And so that's why we thought notice to the ombudsman so that, or on the DMH side, the ombudsman makes sense. On the Dale side, it may be the Disabilities Council, whoever you decide there. But then we can assure that there's those conversations happening and they can consult with counsel because again, it's in the courtroom where people are going to have the opportunity to explain to the court that we haven't met the burden. And so this assures that not just legal aid, but other folks are also able to go to court and express a position or work with legal aid offline to develop their own testimony, their own expert witnesses, whatever they think they need if they don't agree with our decision.
Okay, got it. It's complicated. Good. Senator Hardy has a question, and then Senator Gould.
Well, one, I would really like, I think I asked this the other day, I'd really like to hear from legal aid at the Disability Rights Council and
We
ombudsman.
asked,
So that,
Kiki, did we ask someone to come in? Yeah.
to hear what their thoughts on this are. To me, the way that the panel is right now, it seems duplicative of what's already happening. But, so I just wanna ask Katie a question. I mean, even as it's drafted with the panel existing and under current law, the commissioner is ultimately the one that makes the decision.
So the recommendation,
Or the recommendation, yes, sorry. So, I mean, even with the panel, they're just making a recommendation to the commissioner who's making a recommendation. So it's just an added layer, but it's an added layer right now of all internal people, other commissioners and internal people. So it seems unnecessary to me as it's currently drafted, so.
Can I say something?
Sure.
Thank you. It seems as though the crux of the matter, or the question that we should be asking is the panel the decision-making body, or is it there to listen to victims and so that victims can be heard? And, you know, there can be a voice that is heard by a body, because that's a really important distinction.
Right, so the victim side relates, and I'll let Katie or Stuart or Karen respond to this, but that would be legal aid could be defending the victim or the defender general. So do you want to speak to where the victim's voice is in this process?
as drafted, the panel is not the entity that's hearing the victim's voice. That is an entity that is making a recommendation as to where the person should be placed.
Alright, so there's a decision-making body that.
But no, it's not, it's just a recommendation, it's making a recommendation to the commissioner about whether or not somebody should be committed.
Some,
Okay.
And it's,
Making a decision about a recommendation.
and it's not, listen, it doesn't have any role, the victim doesn't, and the person themselves doesn't, nobody does, it's just they're looking at.
Alright, I thought that's what I heard a couple days ago, but apparently not. Alright, thank you for that.
So
Thank you for doing that.
I wonder if I might comment on that. I think the thing to remember is this is a place where the criminal justice system is interacting with the civil mental health and intellectual disability systems, but they're not the same thing, right? So what we're talking about here, what the commissioners are determining is whether or not the person meets the clinical standard to go to a facility. That is very different from what the victim really has no say in that, right? Like it's not about the public safety part of it necessarily. It's about where is the appropriate place for the person to receive treatment. However, That doesn't mean that the state's attorney is a party to these actions. And so it is the state's attorney in court that is representing the victim, right? And so they are telling the court what the victim's position is. The victim could go, right? In criminal court, these proceedings are open. In family, they are not. But there is that avenue in the court through the state's attorney. Does that make sense? But the commissioner is only looking at the clinical need. It's the court that's examining all the options.
Thank you for that. Yep,
Okay,
so it's,
any other questions there? So I don't think we've resolved anything here, but we do have legal aid coming in on Tuesday. So we can come back to this, but Stuart, you said you had some language that might be different from what's here. Perhaps we could look at that as well on Tuesday. You're muted.
There we go. Sorry about that. Yes, actually, Karen put some great language together, I think, but it will all depend on what the committee's policy decision is as to whether the panel is still needed. If it's not, this is an alternative to that.
Okay,
I'm happy
good.
to send it to Katie.
Okay, that would be great. That would be terrific. And just from my perspective, I think it's really important that the commissioner be informed by the experts who exist in the world of mental health and disabilities, and then what's possible. That's the overarching administrative decisions through human services. So I do think there needs to be something here, whatever it is, and then Department of Corrections with its own interest in where someone is placed depending on their clinical evaluation. All of that is difficult, to say the least, complicated. Okay. All right, so we've got some ideas there. I don't think we've resolved anything with the panel as yet. I'm just gonna ask, my interest is to keep something here. So some decision-making that helps, or information that helps the commissioners make decisions.
But wouldn't they, under current law, have, I mean, they have, the commissioner could always reach out to another commissioner and be like,
They can always do that, but what is in current law, Katie?
I mean, there's nothing that would prohibit commissioners from meeting and talking about what to do with a particular person. Whether the friendly facility is the appropriate placement. They would be required to do that in the absence of language, but they wouldn't be prevented. What you gain, maybe not so much here, but in the next section is the criteria by which a recommendation, sort of having that list of the clinical factors, and you change it to the risk of harm factors, having sort of a step-by-step list of what should be looked at is, and you don't necessarily need a panel to do that. You could also, have language that says the commissioner's recommendation should be based on this list, but that is sort of like what you get, so.
Okay. I think we need something, so, all right, so we're on page 2.
Let me pull it back up. Do I have it back up?
No.
Sharing? I'm looking at it. Okay.
All right.
So we were at the Human Services Community Safety Panel. You asked for some changes. I did some cleanup here with the multiple verbs. We added subdivision 1, risk of danger to self or others. And then we have a possible conversation about adding extra people. In that place in the top of the next section, you've added persons before legal guardian. And then we have this new language, and this is when is the panel meeting? So first, in subsection B, and it talks about how once there's a report concerning a person's competency or sanity, this is finished, then the panel may conduct a hearing on its own or review on its own initiative to decide whether or not forensic facility is appropriate. And the review shall inform what the Commissioner of Mental Health or Dale is going to ask for in terms of placement for the person. And then subdivision 2, there's language about what happens if the panel does not decide on its own initiative to do this review. And then this provides a process by which interested parties could ask the court to have the panel do the review. Then in C, we have what is the content of the review? What factors are being evaluated? And you've made a change to call dangerousness factors, risk of harm factors, but otherwise you've not made any changes to this section. And then we come to admission to the forensic facility for persons in need of treatment or continued treatment. So here is where, before section 4, is where that new section would go from Title 13, if you chose to adopt that language. So in the paper that I gave you today, that would be 4822, and that would be amending Title 13, so it'd be added here. And then you have we jumped to Title 18, you have your definitions, you're adding a definition of forensic facility.
Wait, what page?
6.
Page 6.
Okay. And then we get into the sections that we would be removing from the bill, not deleting what is an existing law, but literally removing language that adds the layer of the forensic facility to it.
So let's skip over. I think we should skip
7, 8,
over, because
9,
we come back to a.
It will make that shorter.
Well, articles.
So 5, 6, and 7.
5, 6, and 7.
Okay, and then we get to the application for continued treatment. And then we had,
Page 12.
12 and 13, yeah.
Okay.
And subsection B, we had a conversation about this, but because there's already a process in place for the secure residential recovery facility and what the commissioner is specifying, this is where treatment is being sought for the person, that we're just sort of like piggybacking on the language that already exists by adding a forensic facility. In the case of the forensic facility, the recommendation of the Human Services Community Safety Panel would be part of the application. I want to make sure you make any changes there.
This was the question, if
Yeah.
we're gonna keep the panel, whether it was a revised or original
Yeah.
recommendation.
That's on 13 lines 12 through 15.
And you had the conversation about how the initial order would be 90 days. But you could be filing, after the initial 90-day order, but you could also be filing after the completion of a full year order. Meaning if the person had an order of continued treatment for a year, and then the commissioner chooses to file again. So it could be, 90 days since the last review, or it could have been a year.
Certainly after a year, could be a new.
Yeah.
In the 90 days, problematic. So maybe there's a distinction to be made there. So maybe the new is after the year. Silent on 90 days. That the initial determination.
So a revised review, a revised panel review would be necessary
After a year.
if it's been more than a year since the last review.
Does that make sense?
That seems like a long time.
It is, but we've also heard 90 days is a short time.
I'm not convinced we need the panel, so I'm not sure that,
Remember something about the panel is that this is a very select group of folks who have, remember the definition of the people who are being considered for treatment in a forensic facility. So they've committed that really serious crime, they've been deemed incompetent. So going back and looking at that, this could be one person. So we're not talking about a whole new cohort, we're talking about one individual who meets these criteria. Which is why having the panel involved, you know, at least having some interested parties engaged is important. That's why I keep going back to that. But
I wonder if I might comment.
please.
Thank you. Just to remind people of the process, right? Because this already exists at Valley. So the orders are for a year at the family court, but we must go back to court and prove, if we wish to keep someone in custody, we have to prove to the court again at the end of that year that they meet standard. And they have an attorney, and their attorney can go to court and say, no, we don't meet standards. So there already is a process whereby we have to be reviewing the clinical need. We have to justify to the court the clinical need, and they have their own attorney who can hire their own experts to say that we're not meeting the need. So this process does exist, and we already do have to do that work. So I just want to be clear that it is happening, and it will happen with or without a panel, because the panel wouldn't change the fact that we have to go to court to do this and that they have their own attorney. Does that make sense?
Yeah, it does. So if we eliminate the revised recommendation, if we have the, you know, take the panel out of this one. Still gonna happen?
Yeah, it has to. We have to prove to the court. We have to file affirmatively with the court before the end of the order is up and explain to the court why we feel that continued placement at the facility or just in our custody in general is warranted. And then the court can say, yes, I agree, or no, I don't. And legal aid at any point can say, yes, we agree. And so and then we would just stipulate to an order. But if legal aid says we don't agree, there would be a contested hearing and each side would present their own testimony and ultimately the court would make a decision.
Okay,
But we have an affirmative obligation to prove to the court every year when that order is up that continued custody is justified clinically.
Should that be a part of this?
well, that is. I mean, that's the question is
Sounds like.
it a panel or is it allowing for the commissioner to make a determination in consultation with interested parties? Obviously, you're going to have to do that. You're going to have to have some consultation to understand the clinical status of the individual. So,
Yes, as I noted, I think yesterday maybe I talked about, so we check in, we have weekly calls with all our facilities and with the DAs too, right? So we know every week, we get an update every week on how people are doing. So we track them throughout the year because again, our obligation is if at some point during the year, they stop meeting criteria, we have to work to discharge them. We don't just wait for the year. We're constantly, looking in them and determining their treatment needs to when they can move to the least restrictive.
so yes, so my concern is that we have something in there that indicates that type of process. We don't have to spell it out by any means, but that there's an ongoing discussion. So maybe it's certainly at this level, it's probably not the panel doing it. Okay.
Right, I would say, I think it's various places throughout the statutes, but basically it comes back to the ultimate requirement of DMH and Dale to serve people in the least restrictive setting possible. There is language in different statutes. I think I sent them to Katie maybe weeks ago, but I can look again about how if any point they're not meeting criteria, we can discharge and our obligation to kind of keep doing that work. So it is happening, but I can relook at the sections if you want them.
Okay, thank you. Go
I
ahead.
just want to say I'm fine with the panel. We're spending a lot of time talking about it. If folks feel like this is useful, then I would.
So we'll go back to the
It's useful.
panel, we'll go back to the
It's
panel
duplicative.
discussion.
They haven't said that.
Well, we'll get Stuart's language on Tuesday, and then we'll go back and have that conversation and what this, that, somehow. That there's a process going on, that there's reassurance to the victim and to the individual who is placed in a facility. That needs something in there that, in statute, that provides that reassurance. It's not just the commissioner. I mean, we've heard that time and again. Don't let it be a person who does this, so.
Right, but I just don't think 4 commissioners is gonna make, if we're gonna have a panel, we need a different panel.
Well-
And if we're not, if we're gonna, it just, the panel as it is now doesn't,
Yeah.
it's just duplicative of what already happens in the system. So either we get rid of it or we make it a different thing is my,
Well,
Or
maybe we're
or it
just,
can remain duplicative.
maybe
There's
we're
a
just,
third option.
yeah, let's see, I'm interested to
just
see
makes
what
the
language.
process
we can-
longer and more complicated and it's already a lot.
It's not, it's one person, it's an individual here we're talking about who's committed a really serious crime. So let's, we're gonna come back to this on Tuesday. Let's go through the bill, then we'll come back to it today if we have some time. Let's do that.
I won't make
I
any,
hear you, I know.
I won't make any changes on page 13 at this point. And then next.
You were hoping that it was.
Whatever the committee decides. Section 9 is the hearing on the application for continued treatment. Again, we already had a structure in place for secure residential recovery facility, and this is piggybacking on that structure. The next section is the application for involuntary medication. As we talked about at the beginning of the hour, we there's a proposed change to the subdivision 6, which would be to end the sentence after non-hospital or forensic facility and strike the language starting at or because you've removed the language around the expedited hearing.
So we'll get to that on Tuesday. Hopefully.
If you'd like, I'll incorporate that.
Yeah, let's
The next
incorporate all those recommendations.
Okay. And then we move from mental illness to intellectual disability at the top of page 15. So section 12 is in title 13. This is the corresponding
What page?
page 18. Just follow along. Okay. Okay, so in this draft, you have an initial order for up to 90 days, but you made a decision that that should be up to 1 year.
Yes.
So I can go ahead and make that change.
Yes.
And then subsection B, we have language that the commitment procedures for an order initially issued pursuant to this section and for discharge, all of the process is dealt with in title 18. So it cross-references the new sections that you're adding in title 18. And then subsection C, in accordance with the language in title 18, if the commissioner seeks to have the person committed pursuant to this section placed in a forensic facility, the commissioner is to provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendation of the panel. So just to sort of ground you where we are, this is the point in the process where the person has had a competency determination, and if they were deemed not competent to stand trial, the court is automatically going to look at commitment. So that's where this is. This is the automatic look at commitment. And this language is saying, but commissioner, if you want the person in a forensic facility, you have to expressly state that to the court and give your explanation for why that setting is appropriate. Then we move into title 18 itself. We have the definitions. This is where the criteria are for what is a person in need of custody care and rehabilitation or continued custody care and rehabilitation. We're removing the same 4 sections that we have been removing since the bill was introduced. And then we get to something's consistent, right? And then we moved to 8845. So 8845
Which is on page.
which is on page 23. Thank you. Is on the initial commitment. 8846 is on the continued commitment. And then 8847 is discharge. So in subdivision A1, if the person is found incompetent to stand trial under Title 13, the criminal division shall automatically schedule a hearing to determine whether the person is a person in need of custody, care, and rehabilitation requiring treatment. So you've already seen that process in Title 13. The commissioner's recommendation that a person shall be placed in a forensic facility, if applicable, shall be filed with the court in advance of the commitment hearing. Shall expressly state the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility and include the recommendation of the Human Services and Community Safety Panel. So that is, that's pretty.
Let's argue about it again.
And that is pretty duplicative of what's in 48, what you've added in 4823.
Yeah.
They're sort of cross-referencing each other. They're trying at least to say the same
Synchrony.
thing.
Yeah.
Alignment.
Yeah, and so, I mean, yes, it's the same process. It's the process by which there's sort of an automatic look at commitment after compensation. Subsection B, the commissioner or designee is to attend the commitment hearing for custody, care, and rehabilitation and be available to testify. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary to conduct the hearing. Subsection C is the rules of evidence. Vermont rules of evidence shall apply in all judicial proceedings brought under the subchapter. Subsection D. If the court finds by clear and convincing evidence that the person is a person in need of custody, care, and rehabilitation, the court is to order that that person be committed to the commissioner, receive appropriate treatment and programming in a designated program that provides the least restrictive environment consistent with the person's need for custody, care, and rehabilitation. Change that for up to 1 year. Subsection E, if, so far we've been talking about commitment, now we're talking about forensic facility. So if the commissioner has already recommended to the court that the person be placed in a forensic facility, the court, after determining that the person is a person in need of custody, care, and rehabilitation, shall determine whether placement at the forensic facility is appropriate and the least restrictive setting adequate to meet the person's needs. If so determined, the court shall order the person placed in a forensic facility for a term not to exceed the duration of the initial commitment order. Okay. Then we move to 8846. This is a continuation.
On this. Go.
If prior to the expiration of any previous commitment order issued under Title 13, so there's been an initial order and now we're doing the continued order. The commissioner believes that the person needs continued care. The commissioner is to file a judicial review in the family division. And the commissioner shall by filing a written petition, commence the proceedings for the continued custody, care, and rehabilitation of the person. Includes the name and address of the person and a statement of the relevant facts for the person's need. And then in subdivision 2, notwithstanding 1, a person may initiate a judicial review under this subchapter at any time after 90 days following a current order of continued commitment. So person is committed for a year, after 90 days, they can ask for a review of that.
And we are leaving address.
Yes, see, that was the. Subdivision 393, any commitment order or continued commitment shall occur in accordance with 13 or the subchapter shall remain in force pending the court's decision on the petition. So that's just saying that once you've filed and the court hasn't made a decision yet and the old order expires, the old order shall stay in effect until the court makes a new decision.
So there's no gap.
Yes. And 4, the commissioner So far we've been talking about continued commitment, now we're talking about placing the person in a forensic facility for continued, during their continued commitment. So if the person seeks placement if the commissioner seeks placement for the person alleged to need custody care and rehabilitation in a forensic facility, the petition must expressly state the reasons for this. And also include a recommendation of the Human Services Community Safety Panel. And then there's an ongoing discussion. And then you've decided in subsection B, if upon receipt of the petition, the court shall set a date for the hearing. And you decided to add language within 10 days from the date of filing. That's what you decided. Which shall be held in accordance with 8845 B and C. That refers to the rules of evidence and who can, who should be in the court, who can come and testify. And subsection C,
Wait, we did say within 10 days, yes.
yes,
Yeah,
within
that's
10
right.
days
10
from the
days.
date of filing, yep. And subsection C, if at the completion of the hearing in consideration of the record, the court finds by clear and convincing evidence at the time of the hearing that the person is still a person in need of continued custody care and rehabilitation. Commitment is to continue in a designated program in the least restrictive environment consistent with a person's need for continued custody care and rehabilitation for up to a year. And if the court finds, so we had, the language I brought you today had a little bit of fine tuning of this language. But if the court finds that at the time of the hearing, the person is no longer a person in need of custody care and rehabilitation, it discharges the person in accordance with the language in the next section. In determining whether the person is in need of continued custody care and rehabilitation, the court considers the degree to which the person has previously engaged in or complied with treatment and programming by the commissioner. And the language I brought today has that new language about sequential orders.
It's green.
It's great. Yes, and then in D, this is what happens with regard to a forensic facility. In a petition where a forensic facility is sought, the court has to first make a determination as to whether commitment is appropriate. If that finding is made, it shall then make a determination on whether placement at the facility is appropriate. And also the least restrictive setting adequate to meet the person's needs. And any order to a forensic facility cannot be longer than the underlying commitment order. 8847 is discharge from either commitment or placement in a forensic facility. So in subsection A, this pretty much says either the court is going to discharge a person or the commissioner. And they could be discharging the person from an initial order, a continued order of commitment, or placement at a forensic facility. In subsection B, this is where our judicial order lives. So basically, if the court finds that a person is not meeting the definitions of care, custody, and rehabilitation or continued care, custody, and rehabilitation, that they could be discharged from the custody of the commissioner. And then in subdivision 2, this is specific to placement at a forensic facility. So similarly, in reviewing the placement of at a forensic facility, the court may determine that while placement at the forensic facility is either not appropriate or not the least restrictive setting, the court can discharge the person from the forensic facility, but not touch the underlying commitment order, which would mean that the person is just placed somewhere else. And then in subdivision B, when a person is subject to a judicial review, is receiving treatment or programming at a forensic facility, either the state's attorney of the county where the person's prosecution originated, or the Office of Attorney General, if they prosecuted the case, or the victim, or both, may file a petition with the court as an interested person concerning whether the person's discharge from placement at a forensic facility is appropriate. I'm not sure if that changed in the new language. I need to double check. No, that looks like it's the same. No, it did change. it changed in that, no, it didn't, that's highlighted in yellow. Nope, we're good. Okay, there is a change in this subdivision C, so now. I should say subsection C, so now we're transitioning, we've been talking about the judicial discharge, and now C is the administrative discharge. So if the commissioner determines that a person is no longer a person in need of either custody or continued custody, the commissioner is to issue an administrative discharge. The administrative discharge may be conditional or absolute, at least 10 days prior to the effective date of any administrative order for discharge by a commissioner from commitment. There's new language, or 10 days prior to the expiration of an order when the commissioner doesn't plan to refile. The commissioner is to give notice of the pending discharge to the committing court and to either the state's attorney of the county where the prosecution originated, or to the office of the attorney general, or both. So this notice is about commitment. It's not about placement in a facility. So at least 10 days prior to the effective date of the administrative order for discharge from commitment is notice. I'm wondering if you want to add forensic facility in there, because the new language that we added is about notice and hearing with regard to a forensic facility, and I don't know how else you would have that notice unless it was given, unless it's further on.
Let's put it in. Yeah, let's put it, if it's not further on, yes.
I need to double check that it's not further on. Okay. Then in subsection, oh, maybe it's,
There it is.
yeah, okay,
It's paragraph.
thank you.
We got it together.
If reviewing the placement of a person receiving treatment at a forensic facility, the commissioner can determine that while the placement at a forensic facility isn't appropriate, that the person might still need to be committed. In that instance, the court can discharge, the commissioner can discharge from the forensic facility, but not from commitment. This is not the same thing.
The notice is on,
So
it's 2A though, isn't it?
But let's be consistent and keep it together. Can we do that, even if it may be redundant?
Yes, let me just take a look at it. Yes, it's in 2A.
Yeah.
Thank you. So I wonder if I have the wrong cross reference. Okay, so in 2A, the person is being administratively discharged from treatment at a forensic facility. The prosecutor, no, because they wouldn't have
They have to be noticed earlier. That was my
they
question.
weren't noticed.
That was my question earlier, when the state's attorney was getting noticed.
So here, they're saying that the prosecutor shall provide notice of the administrative discharge to any victim, but the prosecutor has not received that notice yet. They've only received notice of commitment,
Okay.
so that's where it has to be added in C1A.
Good.
Okay, so I will add that. And then they have the information, so in 2A, the prosecutor can then notify the victim if the victim has not otherwise opted out. And they're only, they are receiving notice both of discharge from placement at a forensic facility and from commitment, if, because it could be one, it could just be that you're being discharged from the forensic facility. It's not necessarily both, but it could be. Okay, next is subdivision B. If entitled to appear and call witnesses in the underlying criminal case, the prosecutor or victim or both may request a hearing on the person's pending administrative discharge from the person's placement at a forensic facility, which shall be heard within 10 days of request. Once the hearing is requested, the pending administrative discharge shall be reviewed by the court.
Shall be stayed until reviewed by the court.
That's the new language that we've added. So we looked at a new B today. I should have done that. So your
Oh,
B here is being replaced.
got it.
I'm gonna read the new one, so we're not as
Yeah.
confused. during the period in which the commissioner gives notice of a pending administrative discharge pursuant to C1A and the anticipated date of the administrative discharge, which shall not be less than 10 days. The prosecutor or victim or both may request a hearing in the family division on the person's pending administrative discharge from the person's placement at a forensic facility, which shall be held within 10 days after the request. And then the pending administrative discharge from placement at a forensic facility shall be stayed. So this section is, this subsection C is telling us that if a person is leaving commitment or placement at the forensic facility, notice is given. But if there is the option for hearing is only with regard to the forensic facility, not commitment. And then we have our language about how when a person is leaving Dale's custody to go to the commissioner of corrections, how the transfer occurs and that the underlying charges are still held by the criminal division. Okay. Then we get to the repeal of the sunset on psychologists doing the competency eval. Page 32, section 15. This is the fiscal estimate for the competency restoration program. And then in section 16, you have rulemaking. I've updated some of this rulemaking language. We already sort of talked through it, but to add in this subdivision to the use of emergency and voluntary procedures. So you'll see that in your next draft. And then section 17 is our effective dates. And I don't think did we land on a date?
You said, you
Yes,
switched
July.
section 15 and 16 taking effect on passage, and then July 1, 25 for the remaining sections.
Great. I also have that written down, so we're literally on the same page.
So I'm gonna go back and I think let's just take a minute and we're gonna take a break.
Yeah, and
This is good. This is very good. And I'm feeling really close. The big issue now is what information the commissioner uses in making decisions about placement within a forensic facility. And so I don't know, Stuart, if you have one more comment to make about this, you or Karen want to make another comment about the panel and very brief comments about the panel, and then we're gonna take a little break.
Well, I did send Katie the language, so I think just now, so Katie, you probably haven't checked your email yet. But I think that the idea behind the language that I drafted was that all of the criteria for the panel would be required to be considered by the commissioner, that there still was a mechanism if the commissioner wasn't seeking the forensic facility, that the state's attorney or another party, it could be the public defender, could ask for us to consider the forensic facility, and then we would need to do so. And then also that it would provide notice to whatever ombudsman or other advocacy group that you may be interested in. So we were trying to address kind of all the needs that you seem to be identifying, but do so in a way that kind of logistically makes sense and also isn't overly burdensome to the department. So I guess it feels like it might be better if you look through the language and we've had a chance to kind of talk through that, but.
Okay, well, we'll look through the language that you've shared with us. Stuart, did you want to make a
Cut
comment?
and paste from our email and I'll send.
Just to piggyback on that, Senator, is to say that this is just a recognition that there is the opportunity for everyone's voice to be heard. It really is a question of at what stage, and we believe that in alignment with the current practice, there is the opportunity for the victims, for the defendant, for the state's attorney to have their voice. That happens to be through the court process.
Yeah.
But that's really all I would say. And the burden is on the department. And if the department doesn't get it right through its recommendation and it can't meet that burden to the court, then the placement can't happen. So everyone gets their chance.
Okay, so we'll look at the language that you sent. Katie, you have it. Maybe we
I'm
can.
sending it to you right now.
Okay, well, let's post it up after. Let's take a break and then we'll we'll come back and look at that briefly. And then we have next Tuesday, this on the calendar for the agenda for next week. And then we'll be able to look at the bill. Hopefully, we'll get to some closure on this question and be able to look at the bill in total. That would be helpful. All right, so we'll come back to this in 10 minutes, so about quarter